Let's dive in. We all make mistakes, right? Nobody's perfect. Nobody's nerfect, as I heard on The Simpsons years ago. We've worked with thousands of families, and we've really seen it all. We've seen every type of family situation, every planning situation, every existing estate plan structure out there, and we've seen a lot of mistakes. So I'm going to go through 5 critical mistakes that we see all the time, and I'm going to go through what you can do to fix them and what you need to think about as you develop and address your own estate planning needs. What are we going to cover here today? The 5 biggest estate planning mistakes. Yes, that's exactly it. Now, what are these mistakes? Mistake number 1, not having a plan, or having a very simplistic plan like just a will and thinking that's enough. 2, not reviewing or updating your plan. It is crucial that not only do you have a plan, but that it's up to date. I'll explore what that means. 3, for many of our families, they just don't think about protecting assets for the next generation. You work so hard to earn your estate, to build your estate. All that can be lost if you don't protect those assets for the next generation. I'm going to go through some of those issues as well. 4, taxes. And the 2 taxes we're most worried about in our line of work, estate taxes and property taxes. So estate taxes, you might think, well, that's only for very, very wealthy people. I'll show why that's not always the case. Property taxes, if you own property in California, there is a new law that you need to be aware of, and there are solutions out there. But literally hundreds of thousands or even millions of dollars can be at stake there. Mistake number 5, failure to coordinate and communicate. A great plan is wonderful, but if you don't coordinate everything, if you don't communicate with the people named in it, the family members who are involved, it can all fall apart. And I want to be clear, this is for educational purposes. It's not legal advice. I can't give that to you unless I meet with you or a firm meets with you. And this doesn't create an attorney-client relationship. We have to be clear about that. This is really meant to inform and enlighten you. And for those of you who don't know us, I just want to give a quick background on our firm and why I'm here today. So I'm a partner at Gilfix and Paul Associates. We are true pioneers in the area of estate planning and elder law. 40 years in Palo Alto. We're very proud of that. We've served thousands and thousands of families throughout the state of California, from San Diego up to Wairika. So we've seen it all. We've served so many different types of families from all walks of life, from just normal everyday people to Nobel Prize winners and to CEOs, but everybody across the spectrum. And I love meeting people from all walks of life, and we can provide value really to everyone. We've saved hundreds of millions of dollars, if not more, in taxes for our clients. But most importantly, our mission and our goal is to empower you and to provide extraordinary value and peace of mind. We're very proud of our place in the community and our place in the legal world. So let's get to that first question. We're going to explore that more, the first mistake. And I first would ask you, do you have an estate plan in place? And if you have questions, by the way, use the Q&A function. I'm going to try to get to some at the end. I can't get to too many right now, but do you have an estate plan in place? Now, the statistics are pretty staggering. 68% of Americans, this is from a recent study by caring.com. I don't know if it's exactly accurate, but according to a recent survey, 68% of Americans don't even have wills. You might be in that group with no documents, but I would say even if you just have a will, that's not enough. A will does not constitute an estate plan. A will is just the absolute minimum, and in many cases, it doesn't help you. It exposes your estate to probate. If you have any assets, if you just have a will, your estate can be stuck in the California court system after you pass away. And very, very importantly, if you just have a will and think that's enough, it doesn't help you while you're alive. So mistake number 1, what happens if you get into an accident? What happens if you have a long-term illness? What if you face dementia? Who can step in to manage your affairs? Who can make medical decisions for you? What would you want if you're in the hospital and can't communicate for yourself? If you don't have an estate plan in place, or if you just have a will, your family will have to step in if they need to help you. If you're out of it, if someone needs to step in and manage your financial affairs, your family is going to have to go to the courts. They're going to have to get a conservatorship, or basically a court order that allows them, that gives them the authority to step in and manage your affairs. It's a very expensive process. It's public. It's painful. You got to show the court what's wrong with you. It's not a good thing. And there are very efficient ways to avoid that. So I have the picture of the DMV there, because if you like dealing with the DMV bureaucracy, you'll love dealing with conservatorships and probates. And really what happens if you don't have an estate plan. So if you don't have an estate plan, how do you fix this? What does an estate plan mean? Well, there's really three core documents. The three must-haves, and I added a fourth here that I'll address later, but really the three must-haves that really everybody with assets, and by assets, if you have over $150,000 or so in liquid assets, and or if you own any property, you need a revocable living trust. Everyone over the age of 18, regardless of how much they have, needs to have a durable power of attorney for finances, not just a check the box form. Ideally, it should be one that's done by an expert because it can address some other issues we'll address later. Everyone over the age of 18 needs an advanced healthcare directive. So the power of attorney lets you name the individuals who can step in to manage your financial day-to-day issues, your business of life issues, dealing with retirement accounts, government agencies, the IRS. Advanced healthcare directives. This allows you to name the people who can communicate on your behalf with doctors, with hospitals, and who can even make decisions for you, very challenging decisions, with your guidance if you need that help, if you can't make medical decisions for yourself. I would add that if you have children and grandchildren, and if you have any assets, I would add a fourth key document, would be considering family protection trust for the next generation. We'll talk about that a little bit later. Now, quick review of why a revocable trust is so much better than just a will. Well, if you have a will, when you pass away, your assets have to go through what we call probate. It's a public process in the California court system. It's expensive. The fees are set by statute. There's no wiggle room. They're very, very high. It's public. Anyone in the public can see us. So when you see a celebrity pass away and all of a sudden you see every detail about his or her plans, James Gandolfini, former star of The Sopranos, when he passed away, everything was public because he just had a will. It's time consuming. It can take up to 2 years or more in some cases to get through the whole process before your loved ones get assets. And it's effective only at death. So creating a will, you name an executor, that person has no ability to help you while you're living. If you're out of it, they can't do anything. They're only empowered after you pass away to oversee this process. And if you have any property in other states, you would have a separate probate in that state as well. A trust, a properly funded trust, means that your assets go to your loved ones privately. They don't go through the court systems. The costs are half or less than the cost of a probate. There's no public access. It's quicker. Your family can really efficiently get through that process in about half the time of a probate. It can vary, of course. And really importantly, a trust lets you name backup trustees who also have the ability to step in and help you while you're still alive, but if you're incapacitated. So between a trust, a power of attorney, advanced directive, you've empowered people with 3 different powerful documents to step in pretty seamlessly to help you if and when you need it while you're still living. Without these, it's an absolute mess. So how do you fix this first big mistake? Well, you have to set up an estate plan. You need to work with an attorney who specializes in this area of law. You don't really want someone who dabbles in this. There are a lot of mistakes made, even how it's structured. We're going to go through that in a second too. And you really want to make sure it's someone who can identify issues that are relevant to you beyond just the basics. Now, better to have a simple plan that's set up properly than no plan at all, but you want to make sure that you're addressing some of the other more sophisticated and challenging issues that I'm going to address as we go through the rest of this presentation, the other mistakes that we make. So I hope you have some new information. If you don't have a plan, you need to set it up. If you do have a plan, that brings us to mistake number 2. Not reviewing or updating your plan. So you might think, hey, I set up a plan. I'm good. I don't need to think about it anymore. I did it. I went to a lawyer and I did it, or I set them up myself, whatever it is. I have a trust. I don't need to think about it anymore. Wrong. Now let's meet John. John is not in a good place. John made some mistakes. He set up his estate plan 15 years ago. He had to get dragged to that meeting by his kids, and he doesn't want to touch it again. 15 years have passed. He's good. He doesn't want to talk to lawyers. He did what he had to do. He's done. Wrong. Tax laws have changed since he set up his plan. Hundreds of thousands of dollars could be at stake there. The people he named in his documents 15 years ago, they're not even a part of his life anymore. This happens all the time. We see people come in. Their first backup trustee was their best friend at the time. Now they're not even on speaking terms. That's a problem. He also failed to address the fact that one of his children, since he created 15 years ago, now has a substance abuse issue. What does that mean? Well, when John faces a long-term illness as he gets older and he can't manage his affairs. Well, he has the trust, he has the power of attorney, the advance directive, but his documents name the wrong people who are not involved in his life. No one is empowered to step in. His family still has to go to court. And when he passes away, he had the wrong trust structure. So he exposed his family unnecessarily to hundreds of thousands of dollars in capital gains taxes, even though he doesn't have a huge estate. Capital gains taxes are a big deal. Your trust structure affects that. And when he passes away, his home goes to his kids, but property taxes spike. They go up 1,000%. I'll go through some examples of that later, what you can do. And really importantly here, let's say one of his kids has a substance abuse issue. Well, he didn't do anything to protect that kid. The money goes to this kid with all these legal and substance abuse issues. That money is gone because there's no structure in place to protect that child. So having a plan is great. But if it's not up to date, if it's out of date, if it doesn't address your new issues, it is not good enough. And so I would say, ask yourself, if you have an estate plan, for those of you out there, if you work with our office, you almost certainly have a plan. Do you have the right people named as your backup trustees or decision makers? Are these people still able to serve? Are they still a part of your life? Do you trust them if they run into problems of their own? Do you have the right beneficiaries named? Do you have any protections in place for them? Do you have age restrictions? Do you have structures? Do they face any issues of their own that you should be aware of? Is your trust properly structured? This mainly applies to married couples, but the structure of your trust can have big tax implications as it relates to capital gains taxes. And are your documents up to date? Do they reflect recent changes in law? So some of the powers that we can grant now weren't even available many years ago. If you have a power of attorney from 25 years ago, it almost certainly doesn't address digital assets, for example. But what if you own crypto? What if you have online bank accounts and other digital assets? Well, it may not even address that issue. And does your plan address property, capital gains, and estate tax issues? I'm going to go through those in just a moment, but you have to think about this in an integrative way. So if you have an old plan, you need to take a fresh look at it. Will a bank even honor an old document? Old power of attorney documents that are old, as they get past 5 or 10 years old, we refer to them as becoming stale, meaning banks don't like to work with old documents. They don't trust them. Now, technically, even if it's valid, you still could run into a lot of trouble. So I would just say this: an out-of-date plan can, in some cases, be worse than no plan at all, because your situation may have changed dramatically. Now, how do you fix this? Well, review your plan with an expert who really understands this and understands all of your issues at least every 5 years, or if your situation changes, or if you see the law change in a way that might affect you, whichever sooner. So if it's been 2 years since you had updated your plan, but someone in your life is no longer that was part of your life when you set it up, is no longer there, well, hey, that's a time to address your plan. If you see something in the news about a state or capital gains tax laws changing, hey, set up a meeting with your advisor and review that, because that could have massive implications for the structure of your plan. You may need to make updates. So again, you need to make sure your plan is up to date. So the worst thing is having no plan at all, but just second worst thing can be a plan in place, but one that's improperly structured, that names the wrong people or assets are going to the wrong place. So make sure you update your plan every 5 years at least, if not more often. Let's go to mistake number 3. Failure to protect assets for the next generation. Now, as we go into this, I would ask you, what keeps you up at night, at least when it comes to your assets? I'm sure there's a lot we're all stressed these days. The world is crazy. But are you worried about your child getting divorced in the future? Have they already gotten a divorce? Are you worried about your child getting sued? Are you worried about how estate taxes might affect future generations, like your grandkids or even great-grandkids, for all you worked for? Do you have a child or a grandchild with a disability or special needs? Do you have a child or grandchild with substance abuse issues, or they're not good with money? They're prone to getting manipulated by bad actors. Think about all these issues. I think most of us are worried about this. The world is a scary place. Leaving assets directly to your child is often a mistake. In fact, I would say it's usually a mistake, given all the tools that we have to protect assets. And I know this takes some wrapping your head around, thinking, wait, why wouldn't I just leave my kids are doing fine? Why wouldn't I leave money just directly to them? Well, I'll address that in just a moment. But let's start with kids with a disability or with special needs. Very, very crucial that you do not leave assets directly to them. Instead, you need to create a special needs trust for their benefit. This is a big part of our practice. It is basically a legal structure that provides a lifelong legal and financial safety net. It's a way for you to leave assets for the benefit of a child with a disability in a way that doesn't interfere with their eligibility for government benefits. It ensures that someone or some entity that you trust will oversee these assets for your child for the rest of their life. And it prevents them from getting manipulated and losing all that money. It can provide this extraordinary lifelong financial safety net that can still allow your loved one or your child to receive needs-based government benefits like SSI or Medi-Cal. And it is the most powerful tool available if you have a child, a grandchild, a niece, a nephew who you want to support after you're gone. This is the structure that can step in to make sure that they have that legal and financial safety net. So this is a big part of our practice. Again, we wrote a book on this. My father, Michael Gilfix, and I wrote the Special Needs Trust Creation and Management Guide. It's available on Amazon, but it is critical. If you have this issue, if you face this issue, talk to us. Make sure you're working with an expert. You need to set up a special needs trust for your child. Now, if you already have one, if this is an issue in your family, you need to review it every few years because you need to make sure that this is up to date. One of the toughest things, the toughest decisions for a special needs trust is who's going to be the trustee of this, who's going to oversee these assets for your loved one. And that can change over time, right? You have to think very long into the future. So very commonly, we'll help families set up a special needs trust. And a few years later, we'll prepare an updated version of it. But a failure to set this up ahead of time can result in the loss of public benefits. It might result in your loved one having to go to court to get a new one created for them, or someone else creating a different type of trust for them. It can just be a big mess. So we have other webinars available on special needs planning. Check the Gilfix Law YouTube channel. We do a lot of events. We speak about this all the time. I'm on the board of the Pacific Autism Center for Education. I work with a lot of families to do that. I'm intimately aware of these issues, and you need to think in an integrative way about this. So if this is an issue, you need to be aware of special needs trust. If you know anybody who faces this issue, let them know, hey, you need to know about these special needs trusts, because I know that for everybody who knows about this, there's probably 3 or 4 families that need to know about it that don't. So please let your loved ones know. If there's anybody in your circle who has a child facing special needs or who has a disability, they need to be aware of this. Now, what if there's not a disability, but you're worried about a child or grandchild who has issues managing money, or they have substance abuse issues, or they are subject to bad influences? Do not leave assets directly to that child. Do not leave assets directly to that child. There are many solutions for different estate planning structures where you can empower someone you trust to oversee assets for those, I guess you could say, problem kids, where you can still support them, but you can be sure that money doesn't disappear, that it's not taken by bad parties, it's not used for drugs or partying. There are a lot of structures. We did a recent webinar on this, protecting children from themselves, on our Gilfix Law YouTube channel. So check that out. There are a lot of different structures. Rather than going into all the different tools, I just want to say that if you face this issue, if you're worried about it, this is another critical mistake people make, where they know there's a problem, but they don't want to think about it. They don't want to overcomplicate their plan. So they just say, I'm just going to leave money to my son. Yeah, he's had some substance abuse issues, but hopefully he'll be fine by then. You can always undo these structures if you need to, but the worst case scenario is all the money that you work so hard for can just vanish, or even make someone's problems worse, and actually leave one of your children worse off than they would have been had they not inherited anything. So lots of tools available there. Special needs trust is just one of them. Now, I mentioned that it's very rare that I think leaving assets directly to a child is a good thing. Instead, you should leave it to a trust. But you might be thinking, well, my kid's doing fine. In fact, my daughter's thriving. She's working at a big tech at Google, and she's making lots of money. She's doing super well. She's starting a family. I don't need to think about this. I still recommend, and our firm, Gilfix & Lefol, still recommends that you don't leave assets directly to that child who is thriving. And to show why, I want to show you a quick mystery, a little tale of supercharging a plan. Larry and Wyatt. So both Larry and Wyatt are doing fine. They have good jobs. They're living good lives. They're married. They have some kids. Both of them have parents who leave them $2 million. Both Larry and Wyatt get this $2 million. Both of them later in life endure a divorce. Both of them get into accidents later in life. As a result of what happens and how the plan was structured by their parents, when Larry passes away, that $2 million is gone. None of it's left. zero left for the grandchildren. Wyatt, on the other hand, inherits the $2 million, still gets divorced, still has the lawsuit, but because of a difference in planning, Wyatt's children end up with $6 million from that initial bequest. And when his children pass away, his grandchildren end up with $18 million. So because of a difference in planning, one family, 2 generations later, ends up with zero. Another family ends up with $18 million. These numbers are not super exaggerated. This is the value, the time value of money. If money's invested over time, and the difference in planning versus not planning. Now, what is the difference? Larry's father left him the money directly. Over time, he commingled it with his spouse. They got divorced. A huge chunk of it was lost in a divorce settlement. Later, he gets into a car accident. He's sued. It's a really bad accident. The rest of that inheritance is gone. No protections. He lost the lawsuit. It's done. His children inherit nothing. So, of course, there's nothing left for the grandchildren. Wyatt, on the other hand, he also got divorced. He also got sued, but he had the benefit of a family protection trust. His dad did not leave money directly to him. Instead, his dad set up a family protection trust for his benefit. As a result, his inheritance was invested well and it stayed separate. So when he got divorced, this trust protected these assets from the divorce settlement. When he got sued, the trust created a barrier that the person suing him said, there's a trust. I'm not going to touch this. It was protected. So that $2 million got to grow to $4 million to $6 million by the time he passed away. It went to his children. And that trust continued through their lives, protecting them from divorce and lawsuits. And it grew to $18 million by the time it got to his grandkids. A massive, massive difference, even though they didn't start with a huge, huge amount. Yeah, $2 million is a lot of money, but that's the value of a home here in Silicon Valley. A not even big home, as I painfully know, as someone who's kind of looking to move closer to Palo Alto. What is a family protection trust? So I kind of illustrated the benefits here, but I'd say the majority of our clients create these trusts for their kids. And this is a way to protect assets for future generations. So if your child divorces, if you leave assets to a family protection trust, there is protection from spouses in the case of a divorce. It keeps assets separate. If your child is sued, assets in a family protection trust benefit from a high level of protection against litigants. Nothing is guaranteed in the eyes of the law. We can't guarantee it, but there are very few cases of anyone successfully breaking this type of trust to get to these assets. So it's a barrier, it's a disincentive for someone suing your child. That can save millions of dollars potentially in a lawsuit. And when your child passes away, this is really, really powerful. We don't know what estate tax laws will be like in 10 years, in 20 years, in 30 years. If you leave assets to a family protection trust, those assets, with some limitations, are not part of your child's estate. They are not subject to estate taxes when your child passes away. That means the money can go from your kids to your grandkids or future grandkids largely free of estate taxes, no matter what the laws, the exemption or the limits are at the time your child passes away. That can save millions of dollars. And you might think, well, this is great, but I don't want to tie my kids' hands. This is my kid who's thriving. They're great with money. They can be their own trustee. So you don't have to tie your kids' hands for them to benefit from these 3 very powerful protections against divorce, against lawsuits, and against future estate taxes. And these trusts last for about 100 years in California. So protections for 2 to 3 generations. And I want to be clear here, so our family protection trust is a type of what is generically known as dynasty trust. It's our form of this. And a lot of people think when they hear the term dynasty trust, they think it's only for the ultra wealthy. And yes, ultra wealthy families, ultra high net worth families have been doing this type of planning for a long, long time. But there's absolutely no reason why the rest of us, why people who only in Silicon Valley is still a big number, but who only own a house in Silicon Valley should benefit from these protections. If you have any assets at all, why not protect the next generation from lawsuits or provide the best protection you can against lawsuits, against estate taxes, against divorces? So we think this is almost a no-brainer for most families. Not a must have, but I would say it almost is. There's recently a report, just to echo this isn't all over the media. If you look up the term dynasty trust, there's a recent report on NPR just talking about how this is how wealthy people avoid estate tax and protects assets for future generations, with the kind of implication that it's not really all that fair. Well, hey, I'm not here to talk about the fairness of different trusts. I'm here to empower you and let you know what's available. And you absolutely do not need to be ultra high net worth for these trusts to be extraordinarily powerful for you and your family. So that is another way to fix mistake number 3. Let's circle back. Failure to protect assets for the next generation. How do you fix this? Well, don't leave assets directly to your children if you really want to protect them. There are a lot of different powerful structures available to protect assets for or from your children while still supporting them. And this really needs to be addressed with an attorney who specializes in multi-generational estate planning. Of course, that's what we do, but you do not want to try this at home. This can get very complicated if it's done improperly, and the wrong structure can cause all sorts of issues. But there are so many powerful tools available. You do not need to be ultra high net worth for these to make sense. So I want you to be aware of these tools. Special needs trusts, family protection trusts, but there are a bunch of other structures that can be set up to protect future generations. So let's go to mistake number 4. This is failure to address property or estate tax issues. This really could be 2 separate mistakes because estate tax issues are separate from property tax. But I just want us to think about tax, because you might think that, hey, I don't have a large estate. I'm way below the estate tax exemption. I have a house, but hey, I don't think these issues apply. I don't need to think about these. And I respectfully disagree. Do you own a home in California? Do you own 2 properties in California? If you own even just your home in California, you need to be aware of the impact of Prop 19. This means that if you've owned your home for a while already, your children will almost certainly face a massive increase in property taxes when you pass away, unless you plan. So Prop 19 basically undid multi-generational Prop 13 protection. So Prop 58 used to allow kids to benefit from their parents' low property taxes, at least for the primary residence, but also for some additional properties. That's gone. There are limited protections for the primary residence, and there are no property tax protections for rental property, or if you have a vacation place, if you're fortunate enough to have multiple properties in California. Everything outside of your primary residence is totally exposed. Now, estate taxes. You might not think that you have a large estate. You might think this is not a worry, but you should be thinking about this. If you own a house in the Bay Area, your house alone could mean that you might face estate tax exposure in the future, because the estate tax exemption is very high. I'm going to go into this in a second with details. The exemption, the amount you can pass tax-free, is very high right now, but it's going to drop on January 1st, 2026. And we don't know what will happen after that, or it could even change before that. So we have to be aware of these issues, because it's a punishing tax. It's 40% of any dollar over the exemption limit. It can be hundreds of thousands or millions of dollars of your hard-earned assets lost to the federal government without planning. So yeah, this is what we're talking about. I think it's versions of taxes that kick in when you pass away. I always point out for this cartoon, I actually wouldn't mind if the Grim Reaper got my tax bill. That would be great, but we don't have any estate planning techniques that can have your tax bills sent to the Grim Reapers. But it just points out when there are major implications for your family when you pass away that you might not be aware of. So let's just spend a moment on Prop 19. We've done a number of talks. We have another webinar that focused really exclusively on how to keep your property taxes low. Check that out, the Gilfix Law YouTube channel. It's available now. We explore this in more detail, but I want to just make sure you're aware of this. Prop 19 is a big deal. It's now law. As of February 16th, 2021, it is in place. Now, what does Prop 19 mean? It means that when you pass away, your home, if your child lives in your home after you pass away, only $1 million in fair market value is protected from a reassessment. If your house is worth more than that, there could be a massive reassessment outside of this relatively small protection. We're talking in Bay Area terms, or coastal California, Southern California, any higher value part of California. $1 million in fair market value is not that much. And if you have other assets, if you have a rental property, if you have a vacation property, no protections. When you pass away, property taxes will be fully reassessed at fair market value. And that means property taxes go up by 200%, 500%. For some of our clients, we're talking about 1,500% increases, literally going up from $2,000 a year to $40,000 a year in some cases. So we're talking about tens of thousands of dollars per year at stake, per year in taxes, if you don't plan ahead or if you're not aware of this and don't take steps. So let's give an illustration really quickly. So let's imagine Tom, Jill, and Andre. They're all in identical places. So imagine them all in the same place to start. Each of them owns a $3 million residence with an assessed value. This is what the Prop 13 assessed value they pay taxes on of $300,000 because they've owned these properties for a very long time. Now, $3 million, I know it's a big number, but again, in parts of California, that's an average house. It's nuts. It's crazy for my generation, but it is what it is. If you're fortunate enough to have owned your house for a long time, whatever it's worth, I would bet that the fair market value, the value you can get if you sold it, is a lot higher than the assessed value that's used to calculate your property taxes. So Tom, Jill, and Andre, each of them passes away and leaves their house to their child. When Tom passes away, his daughter inherits the house and she makes it a rental property. Her property taxes go from $3,000 a year to over $30,000 per year. That's insane. Jill, same thing. She has a house, same value. When she passes away, her daughter inherits it, but her daughter decides to live in it. And I think there's some misconceptions about the new law. They think, oh, if my kid lives in my house, they're good, they're protected. Wrong. Only a limited amount. There's only a limited amount of protection. In this case, property taxes go from $3,000 a year to over $20,000 a year. And this is in perpetuity. This is forever. Andre, on the other hand, same situation. He leaves the property for the benefit of his daughter, but when he passes away, property taxes stay at only $3,000 per year, saving tens of thousands, hundreds of thousands over time, and maybe even millions. What's the difference? Well, Tom and Jill don't like talking to advisors. They didn't do any planning. So when Tom passed away and his daughter didn't live in the house, well, no protections anymore. Prop 19 only provides limited protection if your child lives in the house within a year of you passing away. So if your child just wants to keep your house as a rental, full reassessment of property taxes from in this case, $3,000 a year to well over $30,000 per year. Jill, well, her daughter lived in the house. So you think, oh, well, she's protected a little bit. Only $1 million of fair market value beyond the assessed value is protected in this case. So the assessed value is $300,000. Jill's daughter's living there. So $300,000 is the assessed value. Add $1 million to that, $1.3 million. That's all protected from a reassessment. But hey, the house is worth over $3 million. That leaves a huge portion of the house exposed to a reassessment. So even though her daughter's living there, property taxes go up to over $20,000 per year. Andre, on the other hand, took steps. He worked with us. We've developed an incredible approach to preventing property tax reassessments. We've changed the name a couple of times. We're currently calling it the Checkmate LLC approach that involves trusts and entities. My purpose here is not to talk about all the steps that we take. We can always chat with you about that if this is a concern. My point is to show you why it's so important to be aware that tools exist. Let's just go look at some numbers because I just want to really hit home with how big a deal this can be if you want your kids to be able to hold on to your house. So let's look at this situation. Let's say a home is worth $3.3 million now. Again, it's very possible in many parts of California, but the assessed value is $300,000. Let's assume a family that doesn't do any planning versus a family that's able to protect low property taxes. And the difference in just real dollars, if their kids hold on to the house over time, in 1 year, that's a $33,000 difference in property taxes. And remember, property taxes go up 2% a year. Prop 13 allows 2% a year increases. So once it's reassessed, it will still go up from there. So in 10 years, that's $360,000 in additional taxes. In 30 years, we are talking about a $1.34 million difference in property taxes paid for just the family home, for a family that did planning versus a family that didn't. So the stakes are extraordinarily high. And a lot of people think, well, my kids might just sell the house and be able to buy other property. And they can sell a house when you pass away, but you're kind of tying their hands. They may have to sell if you don't do this planning. And let's say they sell and they buy another property with it that's less expensive. Well, that new property is going to have property taxes at the purchase price that they make. So they sell a $3 million house, no protections. Let's say they put $1.5 million into a less expensive house. Well, property taxes for that new place are going to be set at the purchase price. So you basically have one chance to lock in low property taxes over the long term. And that's why this is so important. So we've developed an integrated approach. It takes about a year to complete, but we've worked with many families to prevent future property tax reassessments. And we can even preserve critical capital gains tax protection, the critical stepped up basis See our recent How to Preserve Low Property Tax webinar on our Gilfix Law YouTube channel for some more details around this issue. But the bottom line is, if this is a concern, talk to us. This is a hard piece of lawyering to achieve, but we still can do it. And we've already helped hundreds of California families with Prop 19 and property tax planning, and we can help you if this is a concern. So just want you to be aware that property taxes are a big deal. If you own property in California, we can help you quickly understand what the stakes are for you and what the options are. Now, not going to spend much time on this, but estate taxes, this is also something we have to be aware of. You see there, Michael Gilfix, I was not involved in this one, but I might be involved in updates. But Michael Gilfix wrote this book, Beat Estate Tax Forever. I think it's also available on Amazon. But we literally wrote a book about how to deal with estate taxes. This is something we think about all the time. Just a couple high-level issues you need to be aware of. The current estate tax exemption, the amount that you can pass tax-free, is $12.06 million per person. That's $24 million per couple. That's a big number. Even in the Bay Area, that's a pretty big number. There's a 40% tax rate on any bequest or gift beyond this. So it's a punishing tax. But really importantly, on January 1st, 2026, the exemption is set to drop in half to about $6 million per person. Now it's indexed to inflation, so it may be a little bit higher. That means $6 million per person and $12 million per couple. Now you still might be thinking, well, those are huge numbers, but keep in mind the estate tax exemption is going to drop right as hopefully the value of your assets are going to continue to grow. I know home prices have sort of flattened, maybe even down a little bit in the Bay Area right now, but you look over the last 5-10 years, most parts of California, real estate doubles in value every 8 to 10 to 12 years. So if you just own a home, if you have investments, they will significantly go up over time, and you need to just be aware of this. And, again, we hear people very logically complain, hey, the rich seem to avoid taxes. Well, that's because they plan, and again, I want to just emphasize, you do not need to be ultra wealthy to think about these issues and to build structures. Most families can benefit from this. So you don't want to, the mistake here, again, failing to address property estate taxes, it's thinking that, hey, I have a trust, I have a power of attorney and advance directive, I'm good. Those help in many ways, but they don't really address estate taxes. So before this approaching deadline, work with an attorney who specializes in an estate tax strategy and make sure that you have the tools at least available. You might not do anything yet, but make sure you're aware of the tools and that your loved ones are empowered to help you if you need it with this type of tax planning. And again, you can see our webinar on this estate planning. We just did a recent webinar on estate planning for high net worth families on our Gilfix Law channel. Getting a theme, we're trying to put out a lot of content here. But see our book, Beat Estate Tax Forever. But most importantly, talk to us about it if this is a concern at all. I think it's an issue that more families face than the families that actually address it. So fixing mistake number 4, failing to address property or estate tax issues. If you've owned a home in California for over 10 years and want it to be available to your children, you need to work with an expert on property tax solutions. And this is a very narrow range of attorneys and firms who understand this, very narrow. And we're very proud of the solutions that we've developed. Now, when it comes to estate taxes, if you're single and your estate's over $4 million today, if you're a couple and your estate's worth over $8 million today, you need to be aware of this because it is very likely you're going to face significant exposure in a few years. So we can help in both areas, but you have to be aware of this. Don't just think that I have a basic estate plan, my estate's not that big, I'm good. There are tax issues that affect well, not every family, but a large number, hundreds of thousands of families in California. I want you to be aware of that. Now, the last mistake number 5, failing to coordinate and communicate. So a plan can be great, but you got to keep it up to date and you need to make sure everything's coordinated. So one area that I really recommend is you want to have a coordinated financial and legal plan. And what does that mean? Well, it's making sure that one hand is talking to the other, your financial advisor is talking to your attorney. Are your assets and property properly titled in your trust? That's a big deal. Your trust, your estate planning documents are really only effective to the extent that your assets are in your trust. So a lot of people set up the plan, they forget to put their investment accounts in the trust. They forget to take the proper steps to get their house in the trust. If they work with us, we make sure a house is in the trust, but maybe you refinance later and the house is taken out of your trust, and then we're left with a big problem. IRAs, 401ks, life insurance. there are a few categories of assets that don't go in your trust, and they're governed by beneficiary designations. Are those up to date? Are those consistent with the rest of your plan? If you set up a trust for your child, you may want to make sure that that life insurance policy, that retirement account, is going not to your child, but to your trust. So failure to coordinate that, failure to stay up to date, can cause major problems. Now, from a pure communication standpoint, does your family know that you have a plan in place? You don't have to share it with them, but if someone's named in your documents to step in for you if you need help, probably a very good idea to talk to them about that, make sure they can do it, to make sure they know where your documents are. So a couple questions I would say. So let's circle back to coordinating financial and legal estate planning. So some questions I would have you ask yourself. Do you manage your own investments, or do you work with an advisor who understands these issues? If you manage your own investments, it's really important for you to even be more closely aligned with your estate planning team to make sure you're doing things properly. And you want to make sure you're working with an advisor who understands the intersection of estate planning and financial planning. Are you investing in assets that make future tax planning more difficult? You want to be a little bit careful. There are certain types of investment products that kind of lock you in. They're not all bad, but there are certain types of annuities and other tools that are great in some situations, but maybe they're not so great in your situation, not necessarily only from a financial planning standpoint, but from an estate tax planning standpoint, where it kind of ties our hands for future planning. So you just want to be aware of that. Is your attorney and your financial advisor, are they communicating? It doesn't necessarily need to be that much. It really depends on the situation, but are they coordinating to make sure your assets are properly titled? Are they talking to make sure that your estate planning attorney knows where you're at financially, to know, hey, it's time for us to talk about this new tool to save millions in taxes? Have you been coordinating to update your beneficiary designations? So I just want to flag that it's really important that your financial advisor communicates with your estate planning attorney. And we're actually building some partnership programs. So for those of you who don't have an advisor and are looking for an integrated team, talk to us. We're developing something I think is really, really exciting and compelling, no additional cost to clients, but really powerful integrated planning. We really believe in that. We've seen it work really well time and time again. So we're building a new integrated financial and legal team for some of our clients. Talk to us about that. But regardless, make sure that your financial planner is at least in touch with your estate planning attorney to the extent you need to. It may not be that much most of the time, but there are critical times where you need to make sure one hand is talking to the other. Now let's talk about family and trusted individuals you name in your documents. Well, if you name someone as a backup trustee or someone in your advance directive to step in and make medical decisions for you if you can't do it for yourself, hey, that person better know they're named. You know, you don't want them to be caught off guard, totally unprepared. Can your loved ones even find your documents when the time comes? So you need to make sure, to whatever extent you feel comfortable, that you talk with your family, talk to your loved ones, talk to the people you've named in your documents. And one thing that is really crucial is multi-generational coordination. That's another big thing that we work with families on. Let's say you have a child with a disability and you set up a special needs trust for your son with a disability. His uncle, his grandparents may want to leave money to support him down the road. If they don't know about the special needs trust, if they don't coordinate their plan with that, they may screw up the plan. We've seen it time and time again where parents set up a great structure for their child, but the uncle with no kids later leaves money to that child and didn't know about the trust, didn't coordinate his planning at all, and that money goes directly to the child, causing all sorts of problems, or we have to go to court to fix it. So you got to coordinate, communicate, and make sure that one hand is talking to the other, that the people named in your documents know that they're named, that you verified they're okay serving, and that they know generally what to do. And a lot of the times we'll do meetings with loved ones where our clients will set up a plan, and a couple months later, we'll set up a meeting where we talk to the kids or other people named. We don't have to reveal everything about the plan. We don't have to reveal what mom and dad have or exactly where it's going, but it is important to at least say, hey, you're named in these documents. Here's kind of what you need to do when the time comes. So fixing mistake number 5, failure to coordinate and communicate. So make sure your financial planning is integrated with your legal planning as much as it can be, making sure title assets are properly titled, that beneficiary designations are coordinated, that one hand is talking to the other. So if an issue comes up, if you're getting close to some of these key tax numbers, we can all work as a team to help you solve these problems. Communicate with your backup trustees, communicate with your family whenever possible. I know that in some families, that's a fraught thing. If there are challenging family dynamics, we can't always do that. We can, of course, help with that. But I think communicating about estate planning is so key. The old school way of looking at this was mom and dad create their document, put it in a safe deposit box, and that's the end of it. That's not the right approach. I think talking, communicating, it generally solves more problems than it causes. It's something that can be a wonderful thing, and it can help you, give you an excuse to talk about your values and your hopes and your dreams for the next generation. So let's just talk about how you can learn more next steps. So we're starting to do more weekly webinars. Check gilfix.com for more information. You can subscribe to our Gilfix Law YouTube channel for more free content, and set a meeting with us. If these brought up issues that you're like, whoa, yeah, I got to think, I got to update my plan. I don't have a plan, right? I want to understand these property tax issues. Set a meeting with us. Our team has worked with thousands of California families. And it's not just me, it's Nick Klingenberg, Renee Conrad, Michael Gilfix, Francis LaPaul, the two guys who really lead our practice. Francis leads our tax practice. Mike is the founder of the field of elder law and really helped to create this firm along with my mother, Myra Gerson Gilfix. So we're very proud of our team. We work with all types of families. It's not just high net worth by any means. We work with families from all backgrounds, all walks of life, first generation immigrants, people who run companies, the whole spectrum, because every family has their own issues. And we have solutions for virtually every situation. But even if you don't work with us, make sure your plan is up to date. Make sure you have these plans, these documents in place, and make sure you think about the issues I raised here. And for those of you interested in working with Gilfix and LaPaul with our firm, I would say set a planning meeting. The way we do that is once we are officially sitting down with you planning, we charge hourly for meetings. Our attorney rates vary from $495 up to $695 an hour, but we are there to serve you from day one. But if you're not sure, if you want to make sure that we're a fit, so if you have these issues, set a meeting. Our calendars get a bit crazy at times, but if you're not sure, or if you haven't worked with us before and want to understand a little bit better if we're a fit and how we do things, we're happy to spend a couple minutes, up to 15 minutes on the phone with you, just getting to know your situation and showing how we can help and making sure you understand how we do things and that it's a good fit. So I would, of course, welcome you to join our client community if you're not already part of it. If you are, and this brought up issues, hey, set a meeting with us. Let's review your plan. If you're not, we would welcome you to our community. You can contact us at 650-493-8070. You can go to gilfix.com. There's a few ways to contact us through our website. We've created a new page /my-needs where you can check boxes for the areas you're interested in talking to us about, and we can set up a meeting with you pretty efficiently. I can set up a time to chat with you, one of our other attorneys. It's always really so powerful just to chat about these issues. It's amazing how quickly we can get to what really matters and how we can add value. So, I think we covered so much here. I get that, and I apologize if it was a little bit too much. I probably really could have called this the 10 biggest mistakes that estate planning California families make in estate planning. I started with 5, and I kept coming up with new ideas that we see. So I hope you got a lot out of this. But yeah, please reach out to us if you're an existing client. Let's set a chance to review your issues. If you're not, hey, let's chat, and if we're the right fit, we can absolutely add a ton of value. And the way that we do things, by the way, is we have initial meetings when we're planning for your billed hourly, and then typically we have flat fees for the rest of the work that we do for you. So you would know from the get-go what the cost would be to complete the recommendations that we make for you. So, okay, we have a couple more minutes. I do see just a couple questions and a couple good ones. So let me just go through these, but I hope you got a lot. Share this video, subscribe to our channel, thumbs up it if you can, if you're watching this on YouTube, but please spread the word and subscribe to our channel. We're going to do a lot more videos, a lot more free content. So let's go to some questions. We had a question about IRAs. How is that protected via trust? And this is a very good question. Retirement accounts don't go in your trust. They're directed by beneficiary designations. Now, an IRA account, you actually can direct IRAs to trusts. Now, there's some tax issues associated with that, but there are ways to protect inherited IRAs. So that's something we could discuss in more detail in a meeting, but there are ways to do that. And actually related to that, someone has a question about those tax issues. If an IRA beneficiary is a trust, when those distributions be taxed at the higher tax rate. So yeah, that's something. So if you have questions about retirement accounts as they pertain to these trusts, talk to us. It's nuanced. It depends on the type of trust. It depends on the situation. There's a different way that special needs trusts are treated versus non-special needs. But the key is, again, I think these questions are really good because whoever asked this, you're thinking about how these tools integrate. You're thinking about how the retirement account integrates with your trust plan and protective structures. So I think that's a very good question. We have other questions about family protection trust. That's, again, a really powerful tool that we would add. Someone asked, like, is that a separate trust? So if mom and dad set up their living trust, is the family protection trust built in? Is that the same thing, or is it separate? A family protection trust is separate. So if you have 2 kids, you would set up your living trust and you would set up a family protection trust for each of your kids, or maybe it's a special needs trust for one kid and a family protection trust for the other. So we like to keep things separate so they can easily be updated. There's tax planning implications and tools we can use. So again, really, really powerful tools available, but we would go through kind of how they flow when we meet with you. And I had just one other question about the Prop 19 issue and the planning. And again, I couldn't go through some of the details of how we do it. It's a complicated process and it varies based on a family situation. But if you have worries about property taxes, meet with us and we can go through it. All we really need to help you explore that is the value of your home today, the fair market value, and the current assessed value. You bring that to a meeting, we can very efficiently go through what the implications of these new laws are and how we can help. So a lot there. I'm going to stop sharing the screen so you can see me a little bit more. Hello, everybody out there. I hope you got a lot out of this. Again, please spread the word, share this with those who you think could benefit from it. Subscribe to our channel, like this. But regardless, hope we get the chance to help you. If you're an existing client, set a meeting, we can go through these issues with you. If you haven't worked with us yet, we'd love to help you take a fresh look at your plan. Whether you don't have a plan or if you did a plan a long time ago, we absolutely can look at a plan set up by another firm and help you understand, hey, is it good as it is, or do we need to make updates or additions? Because again, you do not need to be high net worth for these issues to really, really matter. I think I want to emphasize that time and time again. So on that note, we're going to wrap things up. Contact us through the website, give us a call, gilfix.com/my-needs. Thank you, thank you, thank you. Check out our other videos. I hope we get the chance to work with you, but regardless, I hope you got a lot out of this video. Don't make these 5 mistakes. There are ways to avoid these and to protect your hard-earned assets for multiple generations. So thank you again. I'm Mark Gilfix. Stay safe and healthy.